for the people.
Thank you, Your Honor. Taylor and Anna Preventer on behalf of Mr. McKinry, who's present at the council table.
Also, we are here for final pretrials on these matters, and in 252469 OD, the defendant has alleged bond violations that he failed to appear for a drug test as ordered on September 22nd, September 24th, October 1st. That he failed to appear for an ETG on September 24th and October 1st. Court had him tested today and he tested negative except for positive for THC. He was placed on probation and on bond in this file on June 9th with, among other things, the conditions of no alcohol and random testing, no drugs, including recreational marijuana and random testing. Is there any resolution to these cases at all?
Thank you, Your Honor. We do have an offer from the people of plead guilty to operating while visibly impaired in that file, and then the operating while intoxicated and the domestic violence in the other file would be dismissed. I'm sure Mr. Price can correct me though.
Yes, that is the offer.
We would still like to go forward with that today, if the court would so allow.
Did you say that the other file was a domestic and an operating while intoxicated?
No,
No, there is a 25-4015 SM is just domestic and,
It's an assault and battery.
I'm sorry, an assault.
And then the other is the drunk driving case.
Yes.
All right, okay. What are we doing with the bond violations? I should say, Mr. McKinry, you have the right to have a contested hearing in that matter where the prosecution would have to prove to the court that you did violate the terms of your bond, or you could plead guilty to those bond violations. If you want to talk to your attorney about how you want to proceed, if you haven't done that already.
We have discussed the
Okay.
issue, Your Honor. We would, if the court would want to, since we're ending a plea, we would plead guilty to the bond violations, but we would like to give a little explanation, not necessarily contest the fact that they did happen though.
All right, Mr. Carnes, I assume you don't have an issue with that?
no, Your Honor, that's fine.
All right, so. Did you put those on big sheets?
Yeah, I'm just trying to find the jail credit.
Okay.
But the other one's getting dismissed. You only need one.
Right.
Okay.
Okay, so just so I'm clear, we're pleading to a visibly impaired and then we're dismissing the assault case. And then we're gonna plead to the bond violation as well.
Yes, and the OWI would also be.
Right. Okay. Sir, have you heard what the attorneys have said the resolution in these cases are?
Yes,
And is that how you wish to resolve them?
yes,
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
yes,
It's my understanding that in case number 252469 OD, you'll be pleading guilty to operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail and or a fine of 300. Wait a minute, is that? Yeah, and or a fine of $300. In exchange for that plea, the people will be dismissing the operating while intoxicated, which is another 93-day misdemeanor, but has a fine of not more than $500. Additionally, the case of 254015 SM, the assault and battery, will be dismissed. It's also my understanding that you'll be pleading guilty to the bond violations as well. Is that your full understanding of what's happening today?
yes,
Back on June 6th of this year, were you on probation or parole? You were on bond?
yeah,
All right. Do you remember reading and signing this advice of rights form, talk about your rights to a trial and your rights to an attorney?
yes,
Did you understand those rights?
yeah,
Most importantly, do you understand that you have the right to a jury trial and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind?
yes,
Other than the plea agreement, has anybody promised you anything?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yeah.
Are counsel aware of any other promises, threats, or inducements that are not made part of the record?
No, Your Honor.
No, Your Honor.
Then, sir, to the allegation that on or about June 6, 2025, in the city of Cadillac of Wexford County, how do you plead to the added count of operating while visibly impaired?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on June 6, were you operating a motor vehicle in the city of Cadillac?
Yes.
And prior to operating that motor vehicle, had you consumed alcohol?
Marijuana.
Marijuana?
Yeah.
All right,
The alcohol test came back, Your Honor.
okay. Do you believe that that marijuana would have impaired your ability to operate a motor vehicle?
I think because I was on a new medication that I had an adverse reaction to, and because I didn't let myself figure out how I'd react to that medication, that I smoked the same day I started the medication. It definitely had an effect on me.
How soon prior to operating the vehicle had you smoked?
It was like 5 or 6 hours prior to driving.
Okay. Ms.
If I may as well, Your Honor.
Yes.
You also took a marijuana product that was higher concentrate than what you would normally take that
Yeah,
day.
it was a concentrate cartridge rather than just smoking a joint, which is the higher THC content.
And you knew
So-
it was higher,
Yeah.
and you didn't give yourself more time.
No.
So when you say you smoked, was it a joint or a cartridge or both?
It was a cartridge.
So, okay, all right. Do counsel believe the defendants provided a factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor, we would ask for it acceptably.
As does the court, I find the plea is knowing, voluntary, and accurate. Sir, I find you guilty of operating while visibly impaired pursuant to the plea agreement, the operating while intoxicated, and the assault and battery case will be dismissed. Now then, turning to the bond violations, sir, how do you plead to that you failed to appear for a drug test as ordered on September 22nd, September 24th, October 1st, and that you failed to appear for an ETG on September 24th and October 1st?
I plead guilty to that.
Okay, hold on. I know you want to explain it, but I've got a process I got to go through, all right? So back on those dates, did you know that you were supposed to test?
Yeah,
And did you not test on those dates?
I did not test.
And how was it that you knew that you were supposed to appear for both the drug test and the ETG?
Because my number came up on the Facebook page for community corrections in Wexford County.
Okay, and you knew it had come up
Yeah,
and you did not appear on any of those dates?
no,
All right. The court finds, well, counsel, do you believe the defendants provided a factual basis?
Yes, Your Honor.
Yes, Your Honor.
All right. So we can't, well, I assume we can't sentence today because we don't have a substance use assessment, correct?
We do have a completed assessment, Your Honor.
Okay.
I do apologize, Your Honor. I had copies I have one copy in my file. I thought our social worker had already sent that over to Mr. Carnes. I could run an extra copy of it right now, or.
Well, the court doesn't have time to do one right now, given the docket that I still have to go through. So what we'll do is we'll put this over, we'll set this for a sentencing.
All right. I do apologize. I know that already been sent over to the prosecutor.
So now I have to decide what to do with Bond because he has tested positive for THC. He hasn't tested. So
If I may provide a little additional
You may.
elocution, Your Honor. Obviously, it is not excused, but a major contributing factor for the bond violation was the fact that Mr. McKinry's father passed away on September 21st, is my understanding, or early in the morning of September 22nd. His father was the main person that would help him transport to and from testing. It would also cover the cost. He has very little resources. Without that support, he really struggled to get to and from testing as he needed to. We would also emphasize again, Your Honor, this case all started with an allegation of alcohol. No alcohol was found. There appears to have found in his system. The marijuana is obviously still an issue and still the basis for the plea. But we would respectfully request, especially if the court is not able to go forward with sentencing today, that the court allow him to reinstate his bond with a no marijuana and no driving provision, and some sort of additional testing the court sees fit in consideration of his extremely limited resources and other struggles. It sounds like he is taking the necessary steps where he can to make sure that he has adequate supports in the community. And we would just ask that the court would take all those into consideration. Also, the fact that even though we have had bond issues, he has appeared at all court hearings and been cooperative with staff and the officers when. Thank you.
Thank you. Mr. Carnes?
Thank you, Your Honor. This is a concerning matter for the people in the underlying case. Mr. McInerney's vehicle hit a house, and it didn't hit it hard. It didn't cause damage to the house. It caused damage to the yard. It did actually.
I'm sorry, I can't hear you, Mr. Carnes.
Mr. McInerney's in the underlying file. Mr. McInerney's vehicle hit a house. Didn't hit it hard, but he made contact with it, and there was damage to the yard. Obviously, the occupants of the house and the neighbors were quite scared. So this is concerning behavior, and then it's concerning that he's still testing positive 4 months later. I would ask the court to remand Mr. McInerney pending sentencing, which I would imagine we get to.
Mr. McInerney, first of all, I apologize for your loss. I did see that in the paper, and I apologize for that. Were you still living at the Avon Lane Road or Avon Lane?
That's my mailing address. I live in Lake City, so the commute to the drug house was difficult when my father passed.
Okay. Well, the court's in a tough spot because you hadn't tested as you had been ordered to do. You also had prior violations that you had failed to appear for a test on the 30th of August and that you had failed to enroll in testing. I know that all got taken care of, but while I might be able to, I don't want to say forgive, but maybe overlook the mistests, I can't overlook the fact that you're still testing positive for THC. That was very clear that the court had ordered no marijuana. And clearly you've been on bond since June 9th. That certainly should have been out of your system by now if you had stopped. So that tells me that you haven't stopped. So I've got somebody who drove a car into a house under the influence of marijuana. Mr. Carnes, what was the lab result on that?
Your Honor, it was 22 nanograms per milliliter of the active THC, as well as 5.4 nanograms per milliliter of 11-hydroxy delta 9, which is a metabolite, but it's a metabolite that disappears within an hour. So I did speak with the lab technician on this. She was prepared to testify that is extremely recent use.
Sir, I don't want to say I'm sorry because you did it to yourself. No.
I
No,
just want to.
no, you had your, no. Sir, I'm going to remand you to the custody of the Wexford County Sheriff's Office. Bond is revoked. Court next calls.
There is an assessment and we're looking at the timeline. Do you want to miss it? Or should we try to do that Monday night or not?
Squeeze it in.
Monday?